I'm Drew Stevenson, and this is a lecture for my administrative law class about U.S. Fish and Wildlife Service versus the Sierra Club. This is a United States Supreme Court case from March 2021. So it's a rather new opinion at the time I'm recording this. And this decision is about the Freedom of Information Act and FOIA Exemption 5 and what's called the deliberative process privilege. Now, for my students, two quick words about this. This case is not in our case books, but it's one of the newest examples of the Supreme Court's jurisprudence on FOIA exemptions. This case got some media attention because it was Justice Amy Barrett's first majority opinion on the court. And there's some tradition of those being unanimous opinions. This was a 7-2 opinion. Some of the media headlines, of course, tried to characterize this as a bigger deal than I think it is. This wasn't that big of a setback to environmental groups or advocacy groups because it's really some super specific documents that are covered by this exemption, and it's not even clear to me why these documents would have been useful to the advocacy group, the Sierra Club, that was asking for them. The Sierra Club was able to get thousands of other documents related to the regulation in question as part of their FOIA request. So let's take a look at the case and what it's about. The first thing that's a little confusing about this case is that there's actually two agencies involved. The case is about a FOIA request on the Fish and Wildlife Service, but the documents requested were draft reports that agency had prepared about a proposed EPA regulation that the EPA decided not to promulgate. And the ultimate holding, just to ruin the surprise, is that the court said that Exemption 5 covered the documents in this case. In other words, the Fish and Wildlife Service wins. And it said that the documents are deliberative process documents, and because they are merely drafts of reports and not a final agency action or even something that the agency relied on in its final rule. Here's a nice sentence that I pulled out for you from the majority opinion. I have a couple of these in this video. It is not always self-evident whether a document represents an agency's final decision, but one thing is clear. A document is not final solely because nothing else follows it. Sometimes a proposal dies on the vine, and that is in fact what happened in this case. The EPA was considering a regulation that it ultimately decided was the wrong approach, and they started from scratch and completely changed their proposed regulation and went forward with a different one. So these are documents about a regulation that the EPA decided to drop and not pursue, or at least a version of a regulation, as we will see in a moment. Okay, so the EPA, this is back in, let's say 2012 and 2013, was drafting a new regulation about underwater intakes for industrial cooling systems, which can sometimes harm fish. And it consulted with the Fish and Wildlife Service about this. Later on, after the rule had been promulgated and so on, the Sierra Club, which is an environmental advocacy or conservation group, made a FOIA request for the Fish and Wildlife Service drafts of reports on the harms to fish. But what they wanted, or they got a lot of the documents they requested, but the ones that the Fish and Wildlife Service did not want to turn over were reports, drafts of reports from earlier versions of the EPA's rule, which the EPA ultimately didn't use. Now, here's our first statute. The real operative statute in this case is the Freedom of Information Act, or FOIA, which generally requires federal agencies to make records available upon request, unless those records fall under one of 9 exemptions. And by the way, almost all of the litigation in the FOIA space or about this statute is about the exemptions and what comes under the exemptions and what doesn't. And Exemption 5, as the court explains, incorporates the privileges available to government agencies in civil litigation, such as the deliberative process privilege, the attorney-client privilege, and the attorney work product privilege. Now, if you read Exemption 5 in the statute, it talks about interagency and intra-agency memoranda and other types of documents that are not final decisions by the agency. So I often call this in class the internal memo rule or intra-agency memo rule. But the court here cites a line of fairly recent cases from the last 20 years where they've been talking about it as the government privilege rule. And so this second bullet point that I have on the slide is from a doctrinal standpoint or black letter law standpoint, the main thing that you should take away from this case. Okay, our second statute that's kind of going on here that you need to know just a little bit about to understand this case is the Endangered Species Act, or ESA, which requires the EPA to consult with the Fish and Wildlife Service and another agency called the Marine Fisheries Service about harms to threatened species of fish related to contemplated changes to rules. In other words, the EPA was going to make some environmental regulations about these industrial cooling systems that take water in the ocean or from rivers. And they are required by statute to get and consult with formally these other two agencies. And that means the process is spelled out. The agencies are supposed to draft a report, and then that gets sent to the EPA for consideration, and then it gets sent back before it becomes final, and so forth. So the Fish and Wildlife Service staff drafted reports finding that there would in fact still be some harm, or in the case it talks about jeopardy, there would be jeopardy to fish, threatened species of fish, based on the earliest version or the original version of the proposed EPA rule. Well, meanwhile, Fish and Wildlife Service officials, higher ups in the agency, were still having discussions with EPA officials. And what they told their staffers was, let's hold off on these reports. That sounds like there's still a lot of work to be done, because they could tell from their conversations that there was actually some infighting going on at the EPA over which approach they should take to rulemaking. And so they held off on sending these reports to the EPA, which would be the normal procedure. And sure enough, before they could, the EPA changed its contemplated rule significantly, I would say completely, to avoid harm to fish. So before these drafts of these draft reports about the earlier regulation could even be sent, the EPA sent over a new version of the rule that was very different. And so Fish and Wildlife Service had to start from scratch and do new reports about this new rule, which they thought was a-okay. In fact, one thing to keep in mind about this case is the EPA ended up adopting a rule that was more protective of fish, of wildlife. But those original reports about the earlier versions of the rule remained unpublished at the Fish and Wildlife Service, and the leadership there never sent them to the EPA. Now, let's get to our litigation here. The Fish and Wildlife Service claims that these reports were merely pre-decisional deliberative drafts prepared for circulation, comment, and revision. Importantly, they were not the basis of the EPA's final promulgated rule. The EPA had never even received them. Now, the Sierra Club, on their part, asserted that the Fish and Wildlife Service must have somehow told the EPA on phone calls or something that the reports were going to be unfavorable, so that the EPA could change the rule before receiving the unfavorable reports in order to keep the reports secret. And in other words, they said that these reports, even though they were never finalized and never sent to the EPA, still had an operational effect on the final decision. That was one of the main arguments the Sierra Club made on appeal. And they argued that if the Fish and Wildlife Service doesn't have to turn these over because they're drafts, then agencies from now on can just stamp draft on any document that they want to hide from the public. Here's another quote from the opinion that I like, because Justice Barrett lays out the rule for you about how to apply this. So the earlier quote I told you was the kind of big takeaway. And then here she talks about how to apply the deliberative process document. To determine whether the deliberative process document privilege applies, we must evaluate not whether the drafts provoked a response from the EPA, but whether the Fish and Wildlife Services treated them as final, and they did not. So note here that the majority focuses on how the Fish and Wildlife Service treated these documents. The dissent, which we're going to talk about in a moment from Justice Breyer, and the Sierra Club really focused on how the EPA responded to them. And that's part of why this case is unique and a little confusing, is we really have two agencies. We have one agency preparing a document for the other agency. And one of the parties is focusing on how the authors of the document treated the document, which was that it was just a first draft. And the other party is focusing on how the other agency responded, which is, it seems like they changed their rule, and that's kind of juicy, right? If you're trying to do discovery or you're an advocacy group trying to figure out how the EPA made its decision. And so the EPA responded to these without even reading them, but presumably must have known about their main conclusions. Now, I want to kind of just throw this out there for part of my take on this decision and on Exemption 5, one way to think about this for my students. Other decisions from the courts on the question of judicial review have forced agencies to basically fill the record with lots of deliberative documents. When we get to the part of the courts where we do the Overton Park case or State Farm and some of our other hard look cases, we see this trend that the agency just has a burden of having to pad the file with lots of documentation of exactly how they came up with this decision, and that to show that they considered alternatives and so forth. And maybe Exemption 5 helps balance this burden on the agencies by allowing agencies to select which documents are going to be in the record that is subject to judicial review, or the record of review when the rule is ultimately challenged in court. And that in turn allows the agency to have preparatory documents, right? Post-it notes, doodles on napkins, and or a first draft of a memo where somebody is told, go back to the drawing board, and that will help produce the ones that will actually be part of the rulemaking record. And so because the rulemaking record, according to the courts, has so much significance in litigation and is required to be so extensive, it's obvious that in practice, there's going to have to be a whole bunch of preparatory documents in the process of producing the documents that are going to be part of the actual record of rulemaking. Let's talk about the dissent for a moment. Justice Breyer dissented and was joined by Justice Sotomayor. He sets forth a trichotomy. He says, look, with these Fish and Wildlife Service reports for the EPA, there's basically three versions. There's final reports, there's draft reports, and then there's draft of draft reports. And as an aside, this is the thing I found most annoying about this decision, is when the majority ultimately starts saying these aren't drafts, these are drafts of drafts, which I think is, I mean, a draft is a draft, right? But Justice Breyer takes that and runs with it and says that there's a lot of legal significance between a draft and a draft of a draft. And he argues that the first two, and my first bullet point there, are indistinguishable in practice from a legal standpoint. He basically says that what's called a draft report is really the same and never changes. It becomes the final report, and that the reports in this case are in fact draft reports, not drafts of drafts, with the same legal status as final reports. Justice Breyer focuses on how the EPA uses the Fish and Wildlife Service reports most of the time. And he talks about there's thousands of other cases where the Fish and Wildlife Service has consulted like this for the EPA, and the process that usually happens and what usually happens with the draft reports. And so he focuses on what usually happens rather than the fact that in this particular case, the EPA didn't use them because they completely changed their approach to the regulation. And he says that the majority misunderstands the review and comment process when drafts are sent to the EPA. He says the period, contrary to what the majority says, is not so the Fish and Wildlife Service can revise its report, but so that the EPA can revise its contemplated proposed rule. There's something weird about Justice Breyer's dissent, to be honest. It sounds more like a concurrence, especially as you get to the end, where it sounds like he seems to say, well, maybe the majority's right. And I guess we'll find out on remand. So he says that on remand, a court should decide how tentative these drafts were, and notes that the other agency's draft, that's the Marine Fisheries Service, had lots of markups, underlining and highlighting and things like that, unlike the Fish and Wildlife Service draft reports, which were pristine. They were in their original form. They were never seen by anyone. This is the irony of this, of course, is that the Sierra Club kept arguing, especially, and made a big deal out of this at oral argument, that the agency could just stamp draft on anything they wanted to hide. And the implication, the way Justice Breyer, the language he uses in his dissent makes it sound like as long as they underline things and write notes in the margins and so forth, then they'll be able to hide that. I don't think there's any difference. More importantly, though, Justice Breyer seems to trust the lower level staff, the scientists at the agencies, more than the higher level officials, who might be political appointees at both agencies. I don't think he always talked like this. Justice Breyer's always been the justice who likes the agencies, sides with the agencies, thinks we should trust the experts, and so forth. And this is the first case I've seen from him where he has developed a mistrust of the political appointees. Maybe it's because of the outgoing administration and the concerns about political influence, and seems to now be trusting wanting to give more deference to the lower level people at the agencies. Here's a review question to see if you've been paying attention. An agency directs its staff scientists to prepare a scientific study of the likely effects of a contemplated new rule. The staffer produces a draft report for the supervisors to review. Agency directors can already see that they should change the contemplated rule significantly, and they do so. Does the deliberative process privilege under Exemption 5 protect the draft reports from subsequent disclosure under FOIA? Yes or no? Now, hopefully you know the answer to that. If you don't, I think the answer is that the deliberative process privilege would protect these documents from disclosure. If you're not sure why, you should probably rewatch this video. And that concludes our video about the case, the U.S. Fish and Wildlife Service versus the Sierra Club.